Hello, good morning. I'm happy to see that many of you have decided to join us, and so I'll just go straight into my presentation. It's about developments in the new patent law in Indonesia. It's been several years since we had change in the patent law in Indonesia. The last time we had a change in the patent law, it was in 2001. So it's been around 15 years because it was passed last year. So both the trademark law and the patents law is new now, brand new in Indonesia. So this came into effect in August last year, and it's interesting that Derek brought up costs because there was a presentation yesterday by Eugene about translation costs. So in some countries there's zero translation costs, but in Indonesia, obviously, because English is not the standard language, so there's obviously going to be a translation cost. And I had one client one time send me a translation from Chinese to Indonesian, and none of the examiners could speak Chinese, but most of them could speak English. So it was interesting because I said, you still have to send me the English translation. So if you're a non-English patent holder or a patent applicant and you want to get an Indonesian patent, you have to have an English translation, because then it provides context to a measuring point. So the examiners in Indonesia like to have a reference, so that they prefer to see it in English. Sometimes they prefer even the English, how the patent is drafted in English rather than in Indonesian, because sometimes the translation is not so good. So coming back to my story, this Chinese applicant wanted to file directly from Chinese to English to Indonesian, and they sent me a translation of the patent in Indonesian. And it looked like it went through like Google Translate or something, so it was really bad. So you might save some costs by not translating through a professional translation service, but then down the road you'll get into a lot of problems which might make it more expensive. So I just start my presentation now. So the key new changes are computer programs with technical effect may be patentable now. Before that, you couldn't have that in Indonesia. So you'd have in the previous law they would exclude rules and methods related to computer programs, but now there's a new law. You have the exclusion, and so rules and methods that only comprise computer programs. So if there's a computer program with technical effect, it can be granted a patent. And then then there's the second medical use is also excluded. So it's interesting because there's new exclusions now, and so new use of a known product, and a new form of pre-existing compound which does not offer a significant increase in efficacy. So it's interesting that in Indonesia around 97% of the patents filed are international patents. So you don't have so much domestic filing. I don't know if it's the cost, but maybe it relates to R&D. There's not so much R&D going on in Indonesia, even though we're a very large country. I think the government is still trying to get a lot of innovation. So unlike China, where they've completely adopted a lot of innovation, and more than 50% of their patent system is for the domestic market. In Indonesia, it still caters for a lot of the foreign patent holders, applicants. So it's interesting when one time there was this we were discussing this new patent law with the patent office and the director of patents. He sort of, it was a meeting between all the IP practitioners with the Director General of IP, which is the IP office, and the patent director sort of said, look, I know everybody here is sort of like their main clients are foreign owners, but you should try to get innovators from Indonesia. And it's not that we haven't tried, but it's difficult to get them to invest in patents. So everybody, in trademarks it's a lot simpler, because trademarks I think it's easier to examine, and I think that there's a lot more certainty because the courts have been more consistent in trademarks. Patent litigation is very rare in Indonesia, so don't expect to have a lot of patent litigation in Indonesia, because it's rare. Then the judges don't know too much about it either. So now we have the employee invention ownership. So based on agreement, having consideration to economic benefit obtained from the invention, under the old law, employees were entitled to compensation that was fair, having consideration to the economic benefit obtained from the invention. So the word fair is no longer used. I think maybe fair is difficult to describe what's considered fair. It might be fair for the employee, but for the employer it's different. So it goes back to value. We discussed that also yesterday. And then so simple patent has extended protection to processes, and simple patents were restricted previously to products, and this restriction is now been removed. So in other countries, I think what's considered a simple patent is a utility model. So there's this patent holder's obligation to use the patent too. So this is a restriction that it's some of the pharmaceutical companies that have come into Indonesia. It's sometimes hard for them they have to the patent holder must make the product or use the process in Indonesia. So sometimes for a lot of their products, pharmaceutical companies, they come to Indonesia and they can only it's not economically beneficial to produce the pharmaceutical product in Indonesia, so they just import it. But then there's this mandatory requirement where you have to make the product. And then there's revocation for non-compliance with this article. So there's also there's a shortened period for substantive examination. Under the old law, it was 36 months. Now it's 30 months. I think it was because there was a large backlog, and the new law tries to get for rights holders their registrations faster. So there's a statutory time frame to respond to office actions. It's interesting when you have a statutory requirements because we have a WhatsApp group in between the Indonesian Patent Office and the IP practitioners in Indonesia, and so there was this one time when the practitioners would receive a letter. You have 2 months to respond to this like office action, and you know, the date you received the letter, it's already past the 2 months. So so then we asked, so what happens when you send the letter late? And then they said, just put it in, put in the response that you received the letter late, and then just because it's interesting. Now they have these. They'll send you like the query note when the letter was sent, so you can show that it was proof that you received your letter late. I don't know the process. I'm in Indonesia, in Jakarta. If you have litigation against like an infringer or another party for intellectual property, you have to have the Director General of IPR as the co-defendant, because they're the ones that issued the IP. They're the government body. So, but it's interesting. There have been times when, mostly in trademarks, where you filed a suit against another party for cancellation or deletion, and the other party didn't show up because they didn't want to deal with, okay, I try to pirate this trademark, and then they didn't show up. But then the Director General, the government, would show up, and they would be defending this infringer. So it'd be really funny. And then, but then usually when that happens, because the other party didn't show up, it's an easier case usually. So there's we also have the emergency grants for final extension. It includes force majeure situations such as wars, revolutions, riots. Yeah. So now it's interesting that they put this in, but maybe because we had the huge riots in 1998 when it was the downfall of our former president Suharto. So it's interesting that they put this in, and then you can have post-grant amendments. The new law introduces post-grant amendments procedures. It can be made within like 3 months of the notice of grant, and then you have things on maintenance. There's grace period for late payments for has significantly been shortened. So there's this interesting thing where under the new law, a patent will only be canceled after 3 years of consecutive years of unpaid annuity. And the downside to this was that the annuity continues to be payable for a 3-year period, even if the patent is subsequently canceled. So, so they try to get, there's this assumption that they could simply allow the patent to expire, but then there's this government body, the state audit. They decided that patent holders that didn't pay their annuity, they owed a debt to the government, and then it would still be considered a debt. And then when that happened, it wasn't automatic. So they put this language in so that you could so that there would be no mistake that if it was unpaid, you didn't want your patent anymore. So the new law also includes provisions during the grant of compulsory licenses. We had this, we still have in force, there's this presidential decree where if you have because of the HIV/AIDS crisis, it's possible to produce HIV, medicine in Indonesia. And I think it's still in force. And then you have the Buller provisions. Under the old law, it's a defense to criminal proceedings for a third party to import a patented pharmaceutical product for the purpose of seeking marketing approval during the last 2 years of the patent term. The new law increases this period to 5 years. So there's been an increase in criminal sanctions for patent infringement. It's interesting that there haven't been many cases, but they've decided to increase. I think this is just there's a trend. The copyright law was changed in 2014, and they increased the criminal sanctions. So the trademark law also did that, and so they did this in the patent law. It seems like a large number, but 1 billion is only like $76,000. So there's been discussion by the central bank that they're going to cut like either 3 zeros from our currency. It's not as bad as some countries, but it's still people are still, you know, they don't say, for example, from 1 billion it becomes like 1 million, so it might sound less, but it's still 76,000. That was the reasoning behind it. So that's it, and thank you for listening to my presentation.
Thanks again to all our panelists. Do we have any questions from the audience? I think we have one back here.
Hello, good morning. To the first speaker, please. Can you reflect on the availability of injunctive relief in China?
Availability of injunctive relief, right? Okay. It's somewhat difficult to get preliminary injunction, but for permanent injunction, basically it's automatic if infringement has been found. Most of the time, at least, yeah.
Just a quick follow-up. I think the cases you mentioned this morning were mostly related to patent damages.
You want me to talk about the first case? The first case is about a SEP. It's about a standard essential patent, and that standard is also a government compulsory standard. Most of the time, you would think the court at least shouldn't issue a permanent injunction, except it's exceptional case. But in this case, the reasoning of the court is first of all, the patent at issue is a core patent to that standard, and also is an essential patent. And the plaintiff started to negotiate with Sony since 2009. So about and after about 6 years of efforts negotiating with Sony, with no success, so they have to file a lawsuit in 2015. And during the negotiation, and Sony was unreasonable. One aspect is Sony asked the other party to provide a claim chart on a standard essential patent, and in the meantime, Sony refused to sign a NDA with the plaintiff, and the court thought, okay, those behavior are really unreasonable, and that caused the failure of the party to reach a license agreement. So the court eventually decided to issue a permanent injunction against Sony. But I would say the effect of that permanent injunction may not be that significant, because Sony, I don't think Sony is selling many mobile phones in China anymore. So I would say most likely it's just a gesture or a stand. If one of the party during the negotiation is unreasonable, then the court is willing to do what is right.
Good morning. This is a question for Derek. Actually, in one of your slides, you were talking about how to future-proof claims, and I think that really struck a chord in me from a pharmaceutical patent practitioner, because when you look at companies that are very early stage, there's a tendency to want to pursue claims that are very broad because you want to cover your competitor, exclude your competitors. But then it has this unintended consequence of, bringing in a lot of unintentional prior art that in the long term, it actually does you more harm, because it means that the prosecution is going to be very long, extensive. The patent office is going to balk and then introduce all these kinds of prior art. So I think, having worked at startup companies where I was employee number one to big pharmaceutical companies that were 100,000 people, it just seems to me that another consideration in the way you define the claims is actually the size of the company and the products that you're trying to protect. And I guess what I found was that there's almost an inverse correlation between the size and the stage of the company and the scope of the claim that you're pursuing, where a Pfizer or Novartis might actually go for what we call a picture claim, super narrow, just protecting your immediate product, whereas the startup companies will try to, what are some of the expressions that I've heard? Scorch the earth or claim everything under the sun, and so it just struck me that that's another important consideration too.
Yeah, that's the luxury that more established companies have, is that they can file a lot more narrow patent applications that in the aggregate cover a broad scope, because the budgets are a little bit more established. But with your startups, where you don't have any patents yet, you want to get the most bang for your buck in your first patent. This is going to sound condescending, so I apologize for this, but there's a woman who told me that a cheap man lives an expensive life, and I think that is one of the issues that the startups have to deal with, is in trying to save costs by jamming it all in one patent application. They're actually going to end up spending more in the long run. I think that it really becomes a question of what's most important, and what can you kind of, even if you file a very broad detailed description and draft your claims toward one aspect of whatever the business is, and then file continuations later, that's probably a little bit better idea. And keep in mind, though, kind of what I was getting at is more dealing with the trends at the patent office at the particular time. So I can give the same presentation next year, and my suggestions, my comments will be completely different, because it seems like from year to year things change at the PTO. So. But to answer your question, though, no, I think that's a balancing act that startups have to deal with that I don't think will ever go away anytime soon.
Yeah, no, I totally agree, and I think startups have additional pressures that well-established pharmaceutical companies may not face.
Right.
That they might be worried, interested in making sure that they get to the next round of financing,
right,
so their funding doesn't get cut off, and so. It's not my preferred way of practicing, but I certainly understand that there are additional pressures. But yeah, thank you very much.
Mm-hmm.
As a follow-on to that point, what's your philosophy, Derek, as far as starting with claims of varying scope? So having some claims that are more like a picture claim to put the invention in context for the examiner, with some broader claims also included in the filing?
Yeah, that's a good question. So I've been thinking about this a lot in the last couple of weeks, and in talking with some of the in-house guys. If you can keep your playground to the dependent claims, for example, that will and make the independent claim that two-line variety, and then you satisfy the examiner in in a couple of dependent claims by putting that context in that we're talking about. That's one way to maybe satisfy the examiners. Another thing is to one of the issues that examiners have is also with the detailed description, where we say things like this an embodiment may include this or may include that, and we do it because we're trying to hedge what the invention is. You can put an embodiment in there that this particular embodiment includes this and includes that, but then also say may include or may include this or that. So it could be a mix of both in the detailed description. It could be a mix of both in the claims. But I would recommend just, and these are my thoughts, no thoughts of Harness-Dickey and Pierce necessarily, but I would recommend putting in the. I would recommend keeping your playground to the dependent claims until the examiner says that the independent claim is acceptable or not acceptable.
I think we had a question. Oh.
Hello, my question will be to Mr. Adnan. We don't have any patent applications in Indonesia as being a pharmaceutical company, but I found the patent law too similar to our old patent law, Turkish. Our patent law has changed on 10th January, very recently. We are a country also member of the EPC. So our patent law more close to the harmonized with the EPC now. So we used to have, don't have the second medical use claims too. And you said that you recently excluded them. But you are also a PCT country, so the other from the countries, they can enter, nationalize their patents, and including the second medical use claims. We had the same problem. Even we didn't have the second medical use claims from the EPC or PCT route. They are entering in the Turkey, and they have the protection, especially from the originator countries. Then, as being generic companies, we go to courts, and the judge invalidates all the second medical claims. But if you are not aware, they still continue have the protection. So there were an unfair protection in the market. So we changed it a bit, at least more fairly. So I just wonder how you are dealing with this problem in your country.
Okay, it's still very new, so nobody's really tested it. So I can't really give you an answer right now. But maybe in a year or 2 years from now, we're in close contact usually with the there's the International Pharmaceutical Manufacturers Group. So they're one of the strongest opponents when it comes to anything that has to do with pharmaceuticals. And usually they have pretty good solutions. But like I said, when it's mandatory to have use in Indonesia, that means, so if you have a drug, you're supposed to have a manufacturing facility. So that created problems for all these international pharmaceutical firms, because for some type of drugs, it's just not feasible to produce it in the country. It's easier just to import it, and if you have the demand is not there to justify having a factory. So I'm not sure what will happen. It's still very new. It was just passed in August, and then the trademarks law is even newer. It's been passed in November. So it's still untested. But maybe we can learn from your experience in Turkey.
It won't be easy for you, sorry.
Yeah, it's. I think they just didn't want. Yeah, it's interesting that they decided second medical use wouldn't be, and then we are a member of the PCT and also Paris Convention. So usually, you always get into these types of trouble because you're supposed to, abide by your international obligations, but then you have your, your national legislation that limits what you can do.
Thank you.
Yeah.
Okay, I think that takes all of our time. Sorry, we ran a little bit long. Sorry.
So now I would like to request the moderator to present the memento to our speakers. I know we are running a little late. However, we'll try to catch up late, in the later stage.